The president of the Florida chapter of the Society of Professional Journalists says, "My journalism organization is trying to trademark fake news to stop Donald Trump from using it. Is this serious and can this be done?" My name's Ted Hasse. I'm with Worth Law Office. I'm an intellectual property attorney, licensed and practiced in California. Now, I want to just start off by a disclaimer, noting I've taken a look at the cease and desist letter that they've already sent to President Trump, and it ends this way: "If you fail to comply with our request, we may pursue legal action." But of course, this is satire, which is very different than what you refer to as, quote, fake news. It might be asking too much for you to realize the difference. Signed, Society of Professional Journalists, Florida Pro Chapter. Now, this news is making the rounds, and I was just asked about whether this is for real and whether they can do this. There is a whole media and ethics sort of aspect to this story that I'm not qualified to talk about, but let me talk about the law. In short, as to whether this is real, well, yes and no. Can they do this? No, this isn't how trademark law works. But I do want to talk a little bit about the cease and desist aspect of this as well. First, regarding law on this, registration for a trademark does not create the trademark. Trademark rights precede the registration. It's sort of a memorialization of those claimed rights. So filing an application for a registration for a trademark for fake news means that the Florida chapter of the SPJ claims they're using it as a trademark to designate the source of their goods or services. Now, there's already a beer company, that has a trademark registration for fake news that has gone through the full process and reached full registration. Now, they can prevent the SPJ or anybody else from selling beer under the trademark name fake news, including Donald Trump. However, they can't prevent other people from coming along and registering the trademark fake news for other goods and services. For example, the marketing of absurd publicity stunts could be a service that you might designate under fake news. However, they can't stop people from using the term fake news in a non-trademark way. So they can stop somebody from selling beer as fake news, and somebody else can come along and develop trademark rights around some other goods or services, but none of them can stop Donald Trump or anybody else from using the term fake news in everyday speech descriptively. Now, how is this going to work? In the end, it may not be a lawful application for trademark law on the part of the SPJ, although it may be, and maybe they'll successfully get a registration. However, as I pointed out, that doesn't mean they can stop somebody from using the term descriptively. But if they're sending cease and desist letters, unsophisticated parties may not understand that this effort to restrict their speech is something that's not going to hold up in court. Thousands and thousands of cease and desist letters get sent every day with legal claims that won't hold up in court. And sometimes the recipients even know they won't hold up in court, but they're afraid to have to end up in a legal fight with somebody with more resources. And what can end up happening is people don't do the things they're allowed to do because they're facing frivolous claims from other parties. So, this brings me to cease and desist letters generally. If you get a cease and desist letter related to intellectual property, contact an intellectual property lawyer, talk to somebody who really knows, and they can tell you whether this is serious or not, what you need to do, and how to approach the response.